May 15th, 1990. In a quiet Mulberry, Florida home, 3 members of the Knowles family are brutally murdered. The house is set ablaze. Weeks later, the man who once called one of them family, David Joseph Pittman, is convicted. A jury sentences him to death. Over 30 years later, his final legal fight turns on whether he is intellectually disabled, a debate over IQ scores, childhood schooling, and constitutional precedent. At 6 p.m., September 17, 2025, his life is scheduled to end by lethal injection. This is the story of David Joseph Pittman. David Joseph Pittman was born some decades ago. By 2025, he was about 63 years old. From early on, his life was marked by struggles. School records show that in the 6th, 7th, and 8th grades, he was placed in special education classes and classified as educable mentally handicapped. He was judged to function below grade level and had difficulty with memory and certain cognitive functions. Tests administered when he was young placed his IQ in the range of about 70 to 71. There are also accounts of childhood abuse, physical discipline, neglect, and emotional turmoil. Mental health experts who later reviewed his case described him as having organic personality syndrome, possibly congenital brain damage, attention deficit disorder, unstable mood, difficulties with emotional control. By the late 1980s, Pittman was married to Marie Knowles. Their marriage became troubled, and eventually Marie sought a divorce. That process, bitter and emotionally charged, placed Pittman on a collision course with his in-laws, the very family whose lives would be taken in a night of shocking violence. Mulberry, Florida was a small community in Polk County, a place where people knew each other and where crime of this magnitude was almost unthinkable. But in the early hours of May 15th, 1990, the quiet was shattered by a crime so violent it left the town shaken for decades. The victims were Clarence and Barbara Knowles and their daughter Bonnie, the sister of Pittman's estranged wife, Marie. Clarence was a hard-working man in his 60s, known for his calm demeanor and dedication to family. Barbara, his wife, was described as gentle, protective, and deeply devoted to her children. Bonnie was just beginning her adult life, barely into her 20s, full of ambition and youthful energy. That night, Pittman drove to the Knowles residence. Prosecutors later said he was angry, fueled by resentment over the divorce his wife had filed and the involvement of her family in supporting her separation. Before entering, Pittman cut the phone line, a deliberate act to ensure the family couldn't call for help. Then, armed with a knife, he entered the home. The attack was merciless. Clarence and Barbara were each stabbed repeatedly. Bonnie, too, was struck with brutal force. Evidence later showed defensive wounds, suggesting at least one of the victims fought desperately for their life. The living room and hallway became scenes of horror, the family's final struggle playing out in the middle of their own home. When the killings were done, Pittman set fire to the house. Flames spread quickly, consuming walls and ceilings. The fire was meant to cover his tracks, but investigators were able to determine that the blaze had been deliberately set, an arson designed to destroy evidence. Pittman didn't stop there. He took Bonnie's car and drove it away from the scene. That car, too, he set on fire, abandoning it as a smoldering wreck. The pattern was clear: kill, burn, destroy. Neighbors recalled the eerie glow of the flames and the sirens that followed. By morning, the Knowles home was reduced to a blackened shell. The community, stunned and horrified, demanded answers. And suspicion quickly began to circle around David Pittman. Investigators wasted no time. Pittman's strained marriage and hostility toward the Knowles family put him at the center of suspicion. Witnesses came forward. One said Pittman had spoken of his anger and his threats toward his in-laws. Another testified to seeing him near the burning vehicle belonging to Bonnie Knowles. The strongest testimony came from a jailhouse informant who claimed Pittman admitted to committing the murders. That account, combined with physical evidence and the arson findings, built a case the prosecution was confident in. Pittman was arrested, charged with 3 counts of first-degree murder, 2 counts of arson, grand theft, and burglary. The trial began in early 1991 in Polk County. The courtroom was packed, family members of the victims on one side, Pittman's relatives on the other. The prosecution painted Pittman as a man consumed by rage and jealousy, willing to annihilate his in-laws to retaliate against his wife. They argued that the cutting of the phone line, the multiple stabbings, and the burning of both the home and the car showed clear premeditation and cold calculation. The defense took a different route. They acknowledged Pittman's troubled past and sought to humanize him before the jury. His attorneys presented testimony about his childhood, his history of being placed in special education, his psychological issues, and his difficulty controlling emotions. They argued he was a damaged man, not a cold-blooded killer, and urged the jury to consider life in prison instead of death. Family members testified as well. Pittman's mother spoke of harsh discipline he endured as a child. A psychologist explained that Pittman suffered from attention deficit disorder, organic personality syndrome, mood instability, and long-standing emotional disturbance. These were offered as mitigating factors, reasons to spare his life even if the jury convicted him. But the weight of the evidence was too strong. In March 1991, the jury returned guilty verdicts on all 3 murder charges, as well as arson and grand theft. They acquitted him of burglary. In the penalty phase, emotions ran high. The jury deliberated over whether Pittman should live or die. By a 9-3 vote, they recommended death. The judge agreed, sentencing Pittman to death for each of the 3 murders, plus additional prison terms for arson and theft. For the Knowles family, justice seemed closer. For Pittman, the long march through the appellate courts had just begun. After sentencing, Pittman began the long and winding process of appeals that often define death penalty cases. His legal journey would stretch across 3 decades, winding its way through Florida's state courts and into the federal system. Early appeals raised typical issues: challenges to jury instructions, evidentiary rulings, and whether the death sentences were proportionate compared to other cases. The Florida Supreme Court affirmed his convictions and sentences in 1994, and the U.S. Supreme Court declined to review, making them final in 1995. Then came a turning point in death penalty law: the U.S. Supreme Court's ruling in Atkins v. Virginia, 2002, which barred the execution of individuals with intellectual disability. That decision gave Pittman's attorneys a new line of attack. Pittman's school records showed IQ scores in the low 70s, and records from middle school classified him as educable mentally handicapped. Teachers noted his struggles with memory and academics. Psychologists described him as having emotional instability and impaired impulse control. His lawyers argued these facts placed him squarely under the Atkins protection. But Florida's approach to intellectual disability claims was notoriously strict. For years, the state relied on rigid IQ cutoffs. If an inmate scored above 70, they often were denied relief, regardless of other evidence. This changed with Hall versus Florida, 2014, when the U.S. Supreme Court struck down Florida's cutoff rule, requiring courts to consider a broader range of evidence. For Pittman, though, the timing was everything. He had already filed earlier motions, which had been rejected. When he raised new claims after Hall, Florida courts said they were untimely and procedurally barred. Even when his attorneys brought forward fresh evidence and expert reports, the courts refused to reopen his case. Then came Phillips versus State, 2020, in which the Florida Supreme Court ruled that the more generous standards from Hall could not be applied retroactively. That decision sealed the fate of inmates like Pittman, men whose trials had long since ended, whose claims would forever be judged by outdated standards. In 2021, a trial court denied Pittman's third amended successive motion, ruling his intellectual disability claim was barred. In 2025, the Florida Supreme Court again rejected his arguments, 6-1, with a lone justice dissenting. The dissent stressed that the record contained serious evidence of lifelong disability and that Florida risked executing someone constitutionally ineligible. Still, the majority held firm. They said Pittman had not met the legal standards, that his motions were untimely, and that Hall could not help him. His final hope was an appeal to the U.S. Supreme Court, but no stay of execution came. For David Joseph Pittman, the law's procedural rules mattered more than the disputed evidence of disability. And with that, his fate was set. On August 15, 2025, Florida Governor Ron DeSantis signed a death warrant for Pittman, scheduling his execution for 6 p.m. on September 17, 2025, at Florida State Prison. This would be the 12th execution carried out in Florida in 2025, a record for the state. In the days leading up to the execution, his attorneys filed last appeals, arguing that executing a person with the kind of cognitive limitations alleged, IQ in low 70s, history of special education, school records showing classification as educable mentally handicapped, would violate the Eighth Amendment's ban on cruel and unusual punishments. They asked for stays or evidentiary hearings. On September 11, 2025, the Florida Supreme Court, in a 6-1 decision, refused to halt execution. The majority opinion held that Florida's current law, under Phillips, did not allow Hall's standards to be applied retroactively. The state countered that some IQ tests at trial showed higher scores, an IQ near 95 in one test. The court found that Pittman's claim was untimely and procedurally barred. Meanwhile, his attorneys also submitted a petition for certiorari to the U.S. Supreme Court, raising constitutional issues. No stay arrived. With all appeals exhausted and no stay of execution granted, September 17, 2025, arrived. At 6 p.m., David Joseph Pittman was executed by lethal injection at Florida State Prison. The state carried out the procedure under its 3-drug protocol. The execution was witnessed by officials as prescribed by law. The death sentence was carried out swiftly. With the execution complete, legal closure for this case was achieved. For some, a final end to a crime decades old. For others, a moment of controversy over mental health, constitutional law, and whether justice was fully served. The Pittman case sits at the intersection of cruelty and law. It highlights the tension between evolving legal standards around intellectual disability and procedural rules that limit retroactivity. His case underscores how critical early record-keeping, school classifications, IQ testing becomes decades later. It also shows how state high courts' decisions can close avenues of relief even when new U.S. Supreme Court precedents emerge. Because Phillips versus State is controlling in Florida, many other inmates who were convicted before certain standards changed also find themselves unable to use newer legal protections. Pittman's case may galvanize civil rights, disability rights, or death penalty reform advocates who will question whether the moral force of law aligns with procedural technicalities. That was the full story of David Joseph Pittman, from childhood challenges to the triple homicide to decades of legal battles, and finally, his execution. This has been True Crime Briefing. If you found this video informative, please hit the like button, subscribe to the channel, and ring the bell so you don't miss future deep dives like this. Leave your thoughts in the comments. Do you think justice was served? Was the legal system fair in its treatment of mental health and intellectual disability? Until next time, keep asking questions, because that's where truth begins.